Good morning. I so appreciate your making this a priority in your day. My name is Tim Stevenson. I'm the Executive Director of the Legacy Foundation here at Shell Point. That's always important to mention just in case you and I have never met. As a part of our service to the Shell Point community, we hold these seminars normally monthly. You've had a good month. We just had one last week. And our desire in the course of these seminars is to bring you good, timely, current information that I believe will be of interest. And I pull that interest level from either conversations that you and I have had or something that you may have noted in one of our survey forms. And that brings me to an important point. On your chair, as you came in, is a response device. And that's important to us. And so if I forget to mention that at the end, feel free as you exit to make some notes there. Some people will just leave them on the chairs. Some people will hand them to my staff as you leave. Others will return those to us through the intercampus mail. This week earlier, I was looking at what we are going to have for our winter and spring seminars, and I went back to those responses that you've given us, and that helped guide me in designating what we're going to talk about in the months to come. So that will be very important to us, and I certainly appreciate it. I noticed that we've got a number of what it looks to be family members and people who are interested in your welfare. Welcome to those of you who are not Shell Point residents. We're glad that you're here and trust that this important topic will be helpful to you as we interact about it. So the topic today is the ABCs of estate planning. If I were to give it a subtopic, I would call the subtopic those important questions that are so simple that we're sometimes afraid to ask them. And I think that's important because much of life can be boiled down to the questions that I've been asking all day, but I didn't know if I really ought to ask it. And today is the day to ask those questions. That we will be addressing what we believe to be a number of those issues, as well as some current topics that we have noted as far as some changes in the probate statute here effective October 1st. And then we'll be diving into a number of questions that we believe if people are not asking them, perhaps they should be. One of the reasons why I believe we are hesitant to ask those questions is because we may not realize just how important it is. And we've got a number of reasons that we believe people fail to ask those questions. The first would be, I happen to be in a bank or brokerage firm, and the teller suggested that I do something. I want to tell you that always sends shivers up my spine. Some of the most seemingly innocuous changes that you can make to the titling or to the beneficiary or in some way to how you have an asset registered can have huge impact in your estate plan, and I think it's important that you feel free to ask a knowledgeable attorney those questions. Another area that I see that always makes me cringe is you can depend on Reader's Digest or Ladies' Home Journal, or I'm sure, although I don't read the National Enquirer, I'm sure that you can always find some kind of an article in those magazines about how you should set up your estate plan. And I'm always very careful to try and avoid that. Those things are normally incomplete thoughts at the very least. Then there are the cases where my friend had the same problem, and so I'll just do what they do. The application from one person to another may be totally different. And so I would encourage you to feel free and feel comfortable to develop a relationship with an attorney who can answer those questions for you. Of course, there is always the fear that I might actually have to pay a fee. I recently dealt with someone who, for lack of spending $200 or $300 with an attorney, had to spend $5,000 to get out of the problem. And so I recognize that there's sometimes when fees need to be charged, it's because just like you and me, even lawyers have to be paid for their time. And so I want to be careful that we don't forget good legal medicine just because it may cost us. And most attorneys, here I'll volunteer them, most attorneys will consult with you for free so that you get a conversation going, and then it's only upon the decision that something needs to be done that there's a fee charged. Did I get you in trouble on that?
No, we have our maintenance program a lot of these residents are part of as well. So
right.
Where they get updates without being charged more than the maintenance fee.
So I want you to feel free to develop these kinds of dialogues. And then, of course, in today's world, who needs a lawyer? I've got Google. And as helpful as that can be, and I will admit to you when it comes to a lot of the questions I have about my health and about those kinds of things, I do go and I Google search. But when it comes right down to what my treatment is going to be, I've learned to go to my doctor. And I think that's true also in the legal field as well. We have as our guests today the Shepherd, we call them the Shepherd Law Firm. We've got Craig Hirsch, we've got Michael Hill. Both Craig and Mike are board certified wills and trust attorneys here in the state of Florida. They're longtime friends of Shell Point, and let's welcome them. They're going to bring us our story today.
Thank you, Tim, and good morning. You know that I have been standing here before you here at Shell Point for 20 years now. Really. I did my first workshop when John Shepherd was still at the firm and still working. Now he's retired and doing a lot of philanthropic work. But I stood right here, well, actually not right here, it was at the
Social Center.
Social Center, thank you. 20 years ago I started. So it's nice, many of you are friends and clients, and it's good to see you again. Excuse me. As Tim said, today's topic, we're trying to get more basic, because oftentimes people don't ask, like they'll hear the same word over and over again when they're in the office, trustee, grantor, and they're not really sure what it means, but they're afraid to ask. I'll give you an example. I was at my doctor's office the other day, and he was talking about something called a lipid profile. And, I have a profile, big nose, and he was talking about something about LDL and HDL, and some of those molecules should be big, and some of them should be small. Are you all familiar with this? You probably know more about it than I do. So I go home to my wife, Patty, and Patty asked me, well, are you healthy? I said, beats me. I don't know. But anyway, so hopefully today we'll give you a little bit of background on estate planning basics, some of the things that we talk about almost every day in the office, and we want to make sure you all understand. And if you don't mind, I want to have a little fun today. Is that okay? Because I'm going to put up some multiple choice questions. I'd like some participation. I might put up some words and ask one or two of you to say what the word is and what you think it means. It's okay if you don't get it right. For example, I don't know what HDL still means. Okay? We all play along with me today? Okay, good. So what documents make up a good estate plan? Mostly. Will, right? Will, trust, power of attorney, healthcare surrogate, living will, pre-need guardian, right? That's usually the package that you have. Now, all the documents might be different for each one of you depending upon the type of assets that you own and all those sorts of things, whether or not you're married, how many kids you have. But that's your standard package. So let's first talk about what happens if you don't have a will. Here's my first question for you. What happens if you don't have a will? This is going to be multiple choice, and we're going to find out what you all think. Okay? Because I've been up here before 20 years, now I need these. I didn't need these several years ago. My daughters are all teenagers now. Almost all of them. One of them's not yet, but she's 11 going on 20. So what happens if you don't have a will? A, your assets revert to the state and or federal government. B, your spouse gets everything, like this one. C, your attorney gets everything. I bet you some of you think that. Or D, you are said to have died intestate, and state law says who gets what. What do we all think? D? B? Do we hear B? Okay, some say B, some say D. B might be right if you're survived by a spouse and no minor children. But D is really the right answer. You're said to have died intestate. Intestate means without a will. And then Florida law, because you're Florida residents presumably, Florida law says who gets what. So you have a smart crowd. Mike, I knew we'd have a smart crowd here. But you know what? I got some trick questions coming at you. We'll see how you do. I gave you the easy one first. Let's build some confidence. D is the correct answer. Okay, a revocable living trust. How many of you have revocable living trusts out there? Raise your hand. A lot of you do, right? For those of you who say, I don't know, you're just like me with your lipid profile, right? Okay. A revocable living trust, A, replaces your will. B, saves estate taxes that your will cannot. C, can be changed so long as you are alive and competent. D, always results in probate avoidance. Or E, all of the above. You know what I'm going to do? I
hear some grumbling out there.
Yeah, we got some differences of opinion. Who wants to go on mic and give an answer? Someone? Come on. We need somebody. Okay, no one's volunteering just yet. You're all... Okay, let's see. How many says A? How many raise your hands? Oh, we have someone in the back who wants to make a... Who's that? Okay. I'll bring it back here. Which one do you think, sir?
E.
E?
Mm-hmm.
Why do you think E?
Because I heard you say what they were, and I definitely know it's D. It avoids probate.
Oh, okay, always results in probate avoidance. Okay, so we have an E. And someone else over here, who over here wants to make a guess? Put it right up against your mouth so we can hear you.
It's C.
C.
It
C?
sometimes does some of the others, but it always is C.
Ooh, sharp.
Oh, very good.
That's really good. Okay, let me go through them. A, it does not replace your will. When you have a trust, you still have something called what? A pour-over will, right? A pour-over will acts as a safety net, catches those assets that were not in the name of the trust at the time of your death. You don't want any assets that way, right? Because otherwise, what do you have? A probate. So trusts don't always result in probate avoidance if you have not put all your assets into the trust. That's a real important step. So, your will can save the same estate taxes that your trust can as well. We can do the same tax plan in your will that we put into your trust, but trusts are easier because they're private. You don't have to go through a court process and those sorts of things. So C, the young lady in the back got the right answer. C.
Very good.
Your trust can be changed at any time so long as you're alive and competent. The other ones are all kind of trick questions. So if you thought one of the other ones, that's okay because I intentionally tried to deceive you. And a lawyer who intentionally tries to deceive. Do you believe that? Durable power of attorney. You all have durable powers of attorney. The statute, by the way, changed. October 1st of 2011, this year, the statute changed. All of you who are our clients in our maintenance program are going to get new powers of attorney towards the end of the year. There's a lot more choices. We're going to hold a workshop on that for our maintenance clients on November 8th.
I think.
And anyone, even if you're not a client of ours, you're invited to come. And we'll tell you when and where afterwards. The durable, in durable power of attorney, what does that mean? Let's go through them. A, survives your death. B, survives your incapacity but not your death. Gosh, there's too smart. C, survives your incapacity and your death. No. Or D, comes with a 10-year, 100,000-mile. It's like that guy, the Kia guy. It's huge. Have you seen that guy on TV? Yeah, you all know it, right? What did you all think? B. It survives your incapacity but not your death is the correct answer. So as soon as you die, if one of your kids, for example, is writing checks or paying bills under your power of attorney, that has to stop. That has to stop because now your will or your trust takes over. So durable means it survives your incapacity. So now I'm going to hand it over to my partner, Michael Hill, who is going to give you some more.
All right, next up, living will. The living will. What exactly does the living will mean? Okay, so here are our options. A, states your end-of-life healthcare directions. Okay. Is the same as a living trust, only it's a will. Okay. Says who makes routine healthcare decisions for you if you cannot do so for yourself. D, is the document Terry Schiavo should have had. All right? So, how many say, what do you think the answer is? C. C. We think the answer is C. Anybody think A? Yep, we got a couple. We got Maria in the back, says A. What about B? I like B personally. B's a good one. C, makes routine healthcare decisions. How many think C? Yes, we got a lot of yeses for C. D, the document Terry Schiavo should have had. We got a bunch of yeses there too. Actually, all of them? Not quite. Actually, this has two answers. A, states the end-of-life healthcare directives, and D, the document Terry Schiavo should have had. C, which a lot of folks said, that's actually your healthcare surrogate. That is done in a different document, who makes your routine healthcare decisions for you. It's called a designation of healthcare surrogate. It's also part of a good, well-rounded estate plan. But the living will is where we say, if I'm gone with the hope of recovery, if I'm not coming back, if I'm in a Terry Schiavo situation, what do I want to have happen? Do I want food tubes, water tubes? Do I want the breathing machine? Do I want CPR? Those types of things. Okay, it's not the same as a trust. So if Terry Schiavo would have had this document, we wouldn't know who she was. Remember, in Schiavo's situation, she didn't tell us what she wanted. She wasn't in a position to tell us what she wanted. Husband said she would have wanted to be let go. Family said she would have wanted to live. And so the court battle ensued, and the rest is history. So B and D are the good, A and D are the good answers here. Next up, pre-need guardian. We review a lot of plans that actually don't have pre-need guardians in the estate plan. So what is a pre-need guardian? A, isn't always used. B, names who you would want to serve as your guardian if you should be declared legally incapacitated. So if you become incapacitated, this would name who serves as your guardian. C is an important document in your estate planning arsenal. Or D, all of the above. What do we think? D, hear a lot of Ds. Anybody say anything else? A? Yeah, that's true. D, you're right. You're very smart. Yep. D is the right answer. It's not always used. It's only used in a situation where we actually need a guardianship. Remember, part of why we set up a trust, revocable trust, is to avoid probate, like we've talked about already, but it's also to avoid guardianship. If we become incapacitated, we have a disability trustee take over. Trustee steps in your shoes, and we don't need to involve the guardianship court at all. And so hopefully we never need to use it. But it is an important document in the arsenal because not all of our assets are funded. Not all of our assets are transferred into the trust. Most of them are, but things like IRAs aren't. We've got, that would be income tax. We'd have a big income tax problem if we transferred our IRA. A lot of times life insurance doesn't go in. So if we do become incapacitated, we might need a guardian one day to handle certain assets, and the pre-need guardian tells us which assets, or it tells us who we want to serve as our guardian if necessary. Okay, I like this one. You should review your estate plan how often? At what point in time? When your kids grow up? Okay. When you change your safe deposit boxes. when, when it goes from bank A to bank B and we've got to empty out the safe deposit box, switch over to the next one. C, when you get mad at your children, okay? Every January we always get the calls, hey, my kids or my stepkids didn't send me a card, didn't give me a call. We want to come in and discuss our plan here. Or D, more often than we think necessary. D? Yes, very good. D is the right answer. We need to change it as often as our circumstances change. And Craig's alluded to our maintenance program. A lot of folks are in our maintenance program. We've got a program that, when the laws change, when your personal circumstances change, when your kids change, when your assets change, when you move into a Shell Point type place, you need to think about these things. Don't stress out over them. Don't harp over them. Don't fret over them. But stay active in it. Estate planning is not just a one-time event. It's not something that I do 5, 10, 15 years ago, put in a drawer and forget about it. Because so many things change over life. So it is a process of making sure that your estate plan is up to date when you need it the most, which is either when you pass away or if you become incapacitated. That's when it needs to be effective and up to date.
I want to interact with you
Sure.
a little bit about this side of it.
Right.
I did an estate plan in 1988 after my youngest was born.
Okay.
Is it necessary that I update?
Well, you'd want to take a look. You want to have it looked at. Now, I know you probably weren't a Florida resident when you did this either, correct?
No, that was five states
Five
ago.
states ago. Yes, it'd be a great idea to come in and have it looked at. Let's make sure that chances are it needs to be up to date.
Okay.
It needs to be updated.
Now, does my review of my estate plan only include the documents here, or would the review of my estate plan include things like my life insurance beneficiary designation or my IRA beneficiary designation?
Absolutely.
What about those payable on death designations
Absolutely.
I put on a CD?
One of the things that Craig alluded to, and Tim offered up our free consultation, which we're happy to do, as long as we get a couple things. First off, whenever we sit down with a new client to review the estate plan, we want you to do a couple things for us. First off, give us the documents so we can review the actual documents. If they're Colorado, or if they're 5 states ago, if the kids were still minors and we still have guardianship provisions in there, documents probably need to be up to date. So documents are important. But also we ask that our clients fill out a detailed organizer. It's basically your family information, names, addresses, dates of birth, those types of things. But also a financial statement, a brief balance sheet, because life insurance is important, IRAs are important, TOD, transfer on death, joint accounts. We see a lot of joint accounts with the kids. All those are important in the estate plan because the documents are only going to control those assets that you own in your trust or in your name individually. The IRAs are going to name their own beneficiary. Those are, if they're set up right, they're going to pass outside of your documents. The life insurance is going to name its own beneficiary. Those transfer on death accounts are going to pass outside of your will or your trust. So we want to know about all those so we can make sure that they all line up properly. If we want everything divided, here's a good example. If your will said everything's divided, I have 4 kids. My will says everything's divided 4 ways, equal shares among my kids. And if I have a joint account with my oldest son, who gets that joint account? Do my 4 kids split it like my will says? No, my oldest son does. And so that upsets the apple cart. Now, hopefully he would share with his siblings, but there could be gift tax consequences associated with that, or he might not. If he continues the way he is, he might not share with his siblings. So we've got some real problems if we don't look at everything when we're talking about reviewing an estate plan.
Well, if my mother had meant for me to share with my 6 siblings,
That's true.
she'd have left it to them.
That's
but
true.
I really appreciate the fact that she left it to me.
That's very true. And if you can sleep at night, then you go do that.
Sominex. Sominex. You mentioned, or maybe Craig did, along the way, well, it does here, B.
Right.
Should I be keeping my estate documents in my safe deposit box?
I've got a lot of our clients do. There's no real need to. A lot of times we'll keep some original documents for our clients just as a courtesy. We will need the original will, and we will need the original power of attorney, absolutely. So I'm kind of reluctant sometimes to put them in the safe deposit box or someplace that, especially the power of attorney, where we might not be able to get it fairly quickly. If you do put it in the safe deposit box, make sure you inventory it. Make sure we know what's in there and you keep it up to date. But I don't personally see a need to keep them in the safe deposit box because we're going to need access to them at some point in time. And if we become incapacitated and we can't enter the safe deposit box, and if the original power of attorney is in the safe deposit box, we got a real problem. We got to go to court. We got to get an order getting into the safe deposit box in order to extract those original documents.
I had someone that I was dealing with just this last month that did their will in 1986,
Okay.
and all they have at this point is a photocopy. They have lost the original.
Yeah.
What happens?
Well, there is under the statute, there is a procedure to authenticate a lost will. Okay, if I still have a copy, as long as I have a copy and we can certify. The problem, and Craig, correct me if you've got a different experience, a lot of times the local courts, there's a big presumption that if we can't find the original, we probably destroyed it. And we've got to overcome that presumption. And at least for the last couple that I've had, the judges have said no. Sorry, we're not gonna let it admit it unless I can get maybe the northern attorney who did it, sign an affidavit that he destroyed all of his files and didn't give them to his clients, and that's a lot of hoops to jump through.
So another thing that would make me want to review my plan would be if I couldn't find it.
That's right. Yeah. Yep. Unless you wanted to go under the default rules, which most people don't. So.
Okay.
Okay. Good. All right, so a couple of the updates. Craig alluded to the power of attorney statute. In recent years, the trust laws have changed. Florida homestead laws have changed. Federal tax laws have changed. State tax and trust laws have changed. Florida's durable power of attorney laws have changed. Or all of the above. All of the above. That's just on the legal side. That's just what Congress or what the state legislature or what's happening on the law side. These are all things that the estate plan needs to be updated along with it. And that's not even touching your assets, your kids, your family, your personal changes. So again, a good estate plan is going to stay up to date with both the legal changes and the personal family changes. Just like when the kids were still minors and still had the guardianship provisions, maybe you still had a trust built in until they were 21 or 25. All that's extra language that doesn't need to be built into the plan anymore. And so the plan needs to stay up to date not only with the legal, but also with the personal. Okay?
Okay.
Make sure you're turned
We're going to play a little game show here. What did he say?
on. Not me, not what I just said.
Well, you ever walk out of the office like I did with my doctor and you say, what did he say? Right? Hopefully not too many of you walked out there with me or with Mike thinking that. So, who wants to be my first volunteer for the first, what did he say?
Aren't you recording it?
Yeah.
You will have a CD
We'll have a CD of this? Can I ask you, sir?
There you go.
Tell me what this says and what you think it means.
Well, you need to get an update on your estate
No, I'm saying the word on the screen there.
per stripes.
Per stripes. Do you know what it means?
I have no idea.
No idea. Anyone else want to try what? Yes, sir.
It's not per capita.
It's not per capita. That's right. Anyone else want to try? Go over here.
I think it has to do with your children.
Has to do with children. What's the word say? What's it say?
Per stripes.
Well,
Pete.
per stirpes. That sounds like what? A communicable disease or something. That's awful. Something you don't want to come back to the doctor and say, I got per stirpes. Lawyers throw that around all the time in their offices, don't they? You want per stirpes distribution, don't you? Wouldn't that be a long but? Well, let's tell you what per stirpes means. When your documents say per stirpes, oh, by the way, if lawyers didn't use Latin, why would you need us? Right? Per stirpes literally means by the root. By the root. Right of representation. And here's my example of it. You have the parent, and parent has child A and child B, and child A has grandchildren C and grandchild D. Everybody follow me so far? So if parent's will or trust says, to my children per stirpes, who's it going to? To A and B. Does C and D get anything? That's right, only if A is gone. So if A and B survive parent, and it says to my children or my descendants per stirpes, what that means is child A gets 1/2 and child B gets 1/2. Now, unlikely event, but if A predeceases parent, what do they get? What do I hear? 1/3 each? 1/4, 1/4, 1/2. How many think that B gets 1/2 still? Okay. How many people think that B gets 1/3? Not many. How many people have no idea and don't want to answer because you're in a... Okay. How many people think B gets it all? I heard that. Okay, if it's to my descendants per stirpes and A is predeceased, leaving B, C, and D, B will take 1/2 and C and D each take 1/4. Because C and D, by root, step up into the place of their parent A. Does that make sense? That's how it works. Now, what happens if B predeceases? Does everything go to A, or does C and D get something? Yeah, we're assuming that B has no children. So if B predeceases, when we say to my descendants per stirpes, A gets the whole. Okay, now let me go through one more example just to have some fun here. Attorneys have fun in odd ways, don't we? Let's say A predeceases, and it says, to my descendants per capita. Per capita, not per stirpes. 1/3? Does everybody agree? 1/3? No? Who says different? What do we think? Everybody? Well, that would be 1/3. Yeah. If A predeceases and says per capita, 1/3 B, 1/3 D, 1/3 C. That's how it works. Okay? So most people's documents say per stirpes. In Florida law, by the way, the default, if it doesn't say anything, is per stirpes. Okay, next word. Who wants to read the next word for me? Who's that? Say it for me.
Probate.
Probate. What does probate mean?
Unfortunately, I think it means that you can lose a lot of money.
Good answer.
You can lose a lot of money. That's a good answer. Anyone else want to give me a definition of probate? Who over here? Oh, there we go. Here, wait, hold on. Let me get this in front of you.
Legal handling by the state.
Legal handling by the state. Yeah, that I would say that's good. Anyone else? A different definition. Probate is
A tax liability?
a tax liability.
The judge would make a decision.
The judge
on
makes
that.
a decision.
Gives your people you owe money to a chance to come and get their share.
Okay, gives the people you hold money to a chance to get their share.
It's a legal thing, but it also ties up your estate.
It ties up your estate. It's a
For a
legal thing
long
that ties up
time.
your estate. For a long time. That's good. Ingrid, do you want to tell us what probate means? No, okay. And who else over here said? Yes, ma'am.
It's proving the estate in court.
There you
Proving
go.
the estate
And
in
it costs
court.
a lot of money.
Are you a retired attorney? Oh, there we go. I'm not going to let you answer anymore because you're cheating. Yes.
Distribution of assets by the state.
Distribution of assets by the state. Okay. We're all pretty close. Let me describe what probate is. Probate is a legal process where your will is filed with a court, your creditors are cleared, taxes paid, accounting's filed and approved, and eventually distributions are made to your beneficiaries. It is a court process. And that's why most of us like revocable trust, because we want to avoid that court process. Does that make sense? Probate really has nothing at all to do with taxes other than the fact that as part of the process you want to clear your taxes. Probate is not a tax. So probate is a legal process that we go through. Now, someone alluded to the fact that if you don't have a court process, you don't have to pay your creditors, but you do. Even with the trust process, your trustees have to pay your creditors. I'm still up, right? This next one, personal representative. Who wants to make a guess what this is?
It's your executor.
Your executor. That's right. Don't have to go any farther than that. My kids would tell you that all of my assistants in my office are my personal representatives. They think I don't do any work, that I just sit around, that they're my representatives. And maybe they might agree. Dorothy, do we agree with that? She's not going to answer that question. She's too smart for that. You know, Dorothy, by the way, has been at our firm 40 years? 40 years. Dorothy, yeah, that and she's put up with me for 20, so that deserves a big round of applause. Personal representative is your executor. That's what we call your executor here in Florida. That's the person appointed to handle all your assets in the event of your probate. This is me? Okay. What's this? Who wants to read it? Anyone around here? Okay.
Settlor grantor.
Settlor grantor. Does anyone know what that means? Who is the settlor or the grantor? We'll go over here again. Wait, who we got? Well, you answered just now. Anyone?
The grantor is the party that starts the process.
Starts the process. The party who starts the process. Anyone else around here want to? Where are we? No, you're the lawyer. I'm not. You're I'm sorry, but it's no fun when we have someone with all the answers.
The ringer.
We have the ringer. That's right. All right, we'll go back here. Here, why don't you take this and talk into the mic for us?
Isn't it the person whose estates or assets you're talking about would be the grantor?
Yeah. Is it the person whose assets or estate? When you have a trust, you'll see, like, for example, my trust. Craig Hirsch is settlor or grantor of the Craig Hirsch Trust. I created the trust. So the grantor or the settlor, they're interchangeable words, means that's the person who creates a trust. Think of it, here's how I like to describe it. Mike's going to pick it up right after me. The settlor or the grantor of the bus, if you were a city planner creating a bus route and you wanted the bus to go up on Main Street, north on Main Street, turn right on First, turn left on Maple, that's what the grantor does. The grantor of the trust gets to dictate the trust terms, gets to dictate where the bus goes, where your trust goes, who it benefits, both during your lifetime and at your passing. So now I'm going to turn it over to Mike to describe what the next one is.
What's this word? Trustee. Who knows what the trustee is? Trustee? Yes, ma'am? The one that manages the estate after your death. Okay. Anything else? Anybody else? Trustee? Even when you're alive. Good, good. Yes, both of those answers are correct. The trustee is the one who manages the trust. Back to Craig's example, the bus driver, the trustee is the bus driver. The grantor, the settlor, they create the route, where we're going. They dictate the trust terms. The trustee is the one who actually drives the bus, who actually carries out those terms, who actually does what the grantor, settlor wants them to do. Okay? Now, in most situations, it's you. We're the settlor. I'm the settlor of my trust. I settle my trust. I create my trust. And I'm also the trustee, as long as two things happen. As long as I'm still alive, okay, and as long as I'm still with capacity. Now, a good trust is going to also say two more things about the trustee. who's going to be that trustee when I die? I might want my wife or my oldest kids or my youngest kids. And who's also going to be the trustee if I become incapacitated and I cannot or should not be my own trustee? Okay? So that's the trustee. Also, just as a quick aside, the trustee or the trust also needs to say who decides when I am incapacitated, because I am sometimes usually the last one to know. And so we also need somebody to say, hey, Mike, you shouldn't be your own trustee anymore. You're writing bad checks or you're doing something you shouldn't be. It's time for so-and-so to take over. We call that the disability panel, just for your information. So that's the trustee. Trustee's the one who drives the bus. Okay. Trustee, also one more word. The third party to a trust situation is the beneficiary. Okay, we've got the settlor, the one who creates it. We've got the trustee, the one who manages it, who takes care of everything for the benefit of the beneficiary. Now, most people know what the beneficiary is. It is the person who receives the benefit. They've got the best job of the three. They don't have to worry about creating the documents, dealing with us. They don't have to worry about dealing with Tim and dealing with the banks. They just get to reap the benefits. Now, again, usually you are your own beneficiary as well. You're the sole beneficiary while you're alive. And then it's the kids or the charities or whoever you want to leave your estate to. But the trustee is not necessarily the beneficiary. Very, very different roles. Okay, so we can have a situation where a bank or Tim, for example, are serving as the trustee. They're not taking any money out. They're managing it for somebody else, for you while you're still alive or for the kids after you've passed away. Okay? Funding. Very, very important. We've addressed that a few times. Yes, ma'am? The assets that are in the trust. Okay. Anything else? Anybody else want to tell us what funding is? Yes, sir. The assets that are put into the trust and properly named. Good answer. Anything else? Funding. Funding, both are right on. Funding is the process of transferring your assets into the name of your trust. And not just the trust, it's also making sure that we've got, as Tim was talking about, we've got the beneficiary designations set up properly, that we've got, if we're going to use TODs or we're going to do anything like that, making sure that all the bank accounts are set up properly. Remember, we don't, as we put up on one of the first slides, a trust will not in and of itself avoid probate. I've got a trust, I'm avoiding probate. No. It's a two-step process. I set up the trust, and then I fund the trust. I go down to FindMark, and I get it out of name Michael B. Hill, and I put it into the Michael B. Hill trust account. It's the process of actually doing that transfer. Listing it on Schedule A. A lot of times we've got a trust that's got a schedule at the back. Just simply writing it on that Schedule A is not sufficient. We've got to go to the bank. We've got to actually transfer the assets into the trust. Very, very important. Often overlooked. Also, it's the process of making sure that it's maintained. If we've got a CD at Bank A and it matures and we roll over to a CD at Bank B because it's paying a point or two higher interest, which is fantastic, especially in today's CD rates, we want to make sure that the new bank account is still in the trust. So we want to make sure that we don't inadvertently unfund our trust just because we switch banks or we do something different. Okay, so make sure that not only is it funded initially, but again, it's back to the process of estate planning. Make sure that your estate stays funded and that we never have a probate asset sitting out there. Irrevocable. Irrevocable. Guesses? Can't change it. Can't change it. Good. Anything else? Now one little caveat here is who can't change it? In an irrevocable trust setting, the grantor is typically forbidden from making any changes. So most of our estate plans are set up with revocable trust. We're free to change it, free to amend it, free to do whatever we want to. Yep. Now a lot of times when the first spouse passes away, sometimes irrevocable trusts are set up though. And the irrevocable family trust, credit shelter trust, AB trust, any number of terms are set up for that surviving spouse. Now we typically do that for estate tax purposes and to save estate taxes. And sometimes we do it in a second marriage situation where we want to make sure that a surviving spouse has the benefit, but then it flows back to our children of our marriage, of our first marriage. But a lot of times after we pass, the trusts become irrevocable, meaning that we cannot change them. okay? That the grantor cannot change them. But sometimes, power of appointment. We couple that with a power of appointment. Anybody want to take a guess as to what power of appointment means? No one? Power of appointment? A power of appointment is something that you can give to somebody. Typically, let's use the surviving spouse example. Let's say we've got a husband trust and a wife trust. Husband passes away, and we create a continuing trust for the surviving spouse. Now, it's an irrevocable trust because we want to save estate taxes. Okay, it's irrevocable. But the IRS and the state of Florida say that we can have this power of appointment. And the power of appointment is a power for somebody to change the terms of the trust after they pass away. Okay, so in that situation, first marriage, the family members are all the same, the kids are all the same. I need to create an irrevocable trust just for tax purposes for that surviving spouse, but I can give her a power of appointment so that if circumstances change, she can actually change who the beneficiaries are after she dies. For example, if a child predeceases and we want to do something different than that per stirpes distribution that Craig was talking about, or if we've got a grandchild that's making some bad choices and we want to set up a continuing trust, or if we've got a special needs grandchild and we want to create a special needs trust for somebody. A power of appointment is very, very important because if I've already died and my son develops MS or something much later in life, my trust is irrevocable at that point. Now, with the power of appointment, I can keep that flexible for my wife to change all of our decisions even after I've passed away. So in the right circumstances, power of appointment, very, very important with an irrevocable trust to give somebody the authority to change things without having to go to court. Court's always the last resource. If we needed to go to court to have something changed, we might be able to accomplish that, but there's no guarantee either. So power of appointment, very important for flexibility.
All right. We're going to take, Mike and I will take questions for a few minutes. First, I want to do a couple housekeeping things. In the green folder that you have, I know Tim gave you an evaluation form. We have one as well. If you don't mind, fill that out for us so we'll know your feedback. And on your way out, we have a number of different videos. As you can see, we're videotaping today. And we have videos on all sorts of topics that we've covered in our annual maintenance workshops, perils of joint accounts. We did here with Tim a year or two ago, legal matters when a loved one dies. All those sorts of videos are available. If you're new to Florida, if you're new to Shell Point, if your documents are from out of state and you have questions whether your documents are up to date, that video answers a lot of those questions. So please feel free to take those as you give us your yellow sheet on the way out. Also, how many of you are on Facebook? Any of you on Facebook? No?
A handful.
Handful. We have a Shepherd, the Shepherd Law Firm is on Facebook. You can type that into the box at the top of Facebook, and you can like the Shepherd Law Firm. And when we upload new videos to our website, and you want to watch them, it's all free advice. You can have it. You can have your kids look at it at our website. So look at Facebook, type in the Shepherd Law Firm, and then like the Shepherd Law Firm, and you'll get all of our updates that way as well. It's a new world, isn't it, with Facebook? You know why I'm on Facebook? My teenage daughters, and they wanted to go on. I said, you can go on. I said, but I'm going to create a page, and you're going to friend me so I can see everything that's happening on your page. They weren't too happy about that, but that was the deal. And then now I'm having a lot of fun with it, as it turns out. So in any event, if you have that capability, if you're on Facebook, and by the way, if you're not, it's something to consider with your grandkids and your kids and such.
We had some questions.
So let's go with questions.
I think you didn't mention the fact that you also, on the maintenance plan, you give out a card that attached to your wallet or in your wallet.
Yeah.
That says 24 hours a day you're able to call. For example, if you can't talk and you're taken to a hospital and they want to know you have a living will and you have this and that and the other thing, you have all the documents. And
I owe Bill $20 for promoting our
well, I think that's a great thing.
Yeah, what he's talking about is our maintenance clients, part of one of the benefits of the maintenance program is we have a wallet card that gives you 24-hour-a-day, 7-day-a-week access to your health surrogate and living will. So if you happen to be out of town and your documents aren't somewhere in your back pocket, if something happens to you, you can access them anytime. Yes, ma'am, in the back? The question is a power of attorney from 07 okay? That's kind of a loaded question. We're going to answer that in one of our workshops coming up next week that we're going to spend probably about a half hour, 40 minutes on. The quick answer is you probably want to update your power of attorney if you can, and you're competent, you're fine. I would go ahead and do so. Powers of attorney before the new enactment date, which was October 1st of 2011, are referred to as legacy powers. Do those have to be after 96, though?
Yeah, they still would need to be after 96.
If you have a power older than October 1, 1996, you better update it. If you have one between 96 and 2011, you should update it.
I saw today a power of attorney from 1996.
Yeah.
And so I see in the course of a day these things on a frequent basis. And we talked about the fact in preparation for this seminar, we would talk a little deeper about the new statute. Let's hit some of the high points.
I'll let Mike do that.
And where the concern is.
Yeah, in brief, as brief as I can be, a couple major changes, and they really turn the statute on its head. A couple things. First off, we have new signing requirements. Anything that deals with estate planning, that deals with creating a trust, that deals with doing long-term care planning, funding a trust even, have to be specifically initialed or signed. They really crack down on just a big, thick document that you just sign at the end. They want to make sure that you really know what you're signing and that you understand it, even though we explain it to you and tell you all these things anyway. You actually have to initial. So we've got we've got a whole new section in our power of attorney where we pulled everything together that has to be initialed. So not only do you sign at the end, you initial a whole lot of places. The biggest problem, though, for Tim and for powers for the attorney in fact, the agent, is there's no more general grant of authority. And what I mean by that is if I want to give Craig my power of attorney, and you've probably seen a lot of these, Tim, I know I have, you can have a 1-2-page power of attorney that says, Craig can do anything I can do as if I were standing there present. Okay? So I give Craig the authority to do any and all things that I could do if I were there personally. That is no longer valid to convey any authority whatsoever. If I have a really, really simple power of attorney that's 1 page long, 2 pages long, that says something to that effect, usually it has some legalese at the beginning, then it has that little sentence, and then it's got some legalese at the end, and we've got a really short, simple power of attorney, that's really no longer effective. What we have to do in the power of attorney is we have to specifically enumerate every single power that we ever want this attorney in fact to do for us, this agent, our kids to do for us. So if you want them to sign a check, better put it in the power of attorney. If you want them to be able to trade or to transfer or to fund or to do anything along the way, because what's going to happen is the banks are going to say, well, show me the provision in the power of attorney that lets you do that. Okay? Because remember, we're sitting here, the kid's sitting here now with the bank. Mom or dad's typically in the hospital or something's wrong, the pavilion or wherever, and can't physically be there or can't sign the check. The kids are now going to have to be able to prove to the bank that, hey, I've got the authority to make this trade, to fund this asset so I avoid probate, to do...
If I could jump in, 20 years ago when I first started at the firm, our power of attorney was about 6 pages long. And everybody used to complain about that. Then it went to 12. Then it went to 18. What's this new version? About 35 pages?
About 35 pages long.
Our new power of attorney is about 35 pages long. Well, it's the law. If you want to complain about it, please don't complain to me. Complain to your state legislator. Because as Mike said, if you want to give someone the power to convey real estate, you have to specifically say they have the power to convey real estate. If you want someone to have the power to make a withdrawal from your IRA on your behalf, there has to be a specific power that they can withdraw an IRA on your behalf. So your mind can wander into all the various things that you might need someone to do for you. Yeah. Create a Medicaid trust. Fund a trust, put assets that aren't in your trust, What else?
I mean, change the beneficiary if we need to. Any number of things, you know. So what? And the reason that it's kind of just built is every time we get pushback from a bank, okay, we put a new provision in, or we adjust it, or we add it, or whatever. Question?
So.
On the trust that we have, these things are addressed in separate paragraphs. Why can we not go back and sign the paragraph? Our signature is on the last page. And then the document is several pages long.
Sure.
But why could we not at this point go back and sign?
Yeah. The question is that they have a trust that's got all these provisions in. Can they just go back and sign and initial? Well, the problem is you've got a trust, and we're talking about the power of attorney. The power of attorney is what has, yeah. Okay, the power of attorney. Well, you know, I don't know what your power of attorney says, you know, so I don't know if it gives all these specific.
Well, that speaks to the
authorities.
signing requirements too.
Yeah.
It's the date and the signing requirements too that are important.
Yeah.
So chances are, I would not take the risk of just initialing next to. You could try that.
Yeah.
But here's the.
But we're talking about guaranteeing that when your kids actually need to use it, you're in the hospital. I don't want to take that risk. I don't want my clients to take that risk. I'd rather just have a good power of attorney that was signed after the first, that had your initial everywhere that needed to be done.
I'm up and close and personal on this because of the people that I know. Right. And I was thinking this week, as we were preparing for this, I've been here four years now, and in the last 4 years, I've seen 4 residents at Shell Point that I know of where the family was driven to a guardianship, and the sole issue in each case was an inadequate durable power of attorney. And so, again, I had a conversation with a resident this week, and he said, tell me why. I said, you know, you're talking a very nominal amount to have your durable power of attorney updated, and we've brought this information. To do a guardianship is $5,000 or more minimum.
Plus an annual fee for county
plus,
every year.
Yeah, plus annual fees. And all of that, in the 4 cases that I've come across, it has been the durable power of attorney that was the failure.
Correct.
And so why does it get my attention? Is because that's a real application to life here when you come across a child who needs to take money out of an IRA to pay the Shell Point bill. Yeah. And the power of attorney is not adequate. Or the illustrations go on and on. But in each of those 4 times, it was the power of attorney that triggered the need for guardianship.
That's right.
So.
I have a power of attorney for a mother who's in a nursing home.
Okay.
Who is incapable of doing another one.
Yeah.
How valid is that going to be?
Yeah. Well, I mean, that speaks to the very issue we were talking about. Mom's in the nursing. The question was, mom's already in a nursing home. Her mother's in a nursing home, and she's incapable of signing a new one. How valid is it going to be? Like Craig mentioned earlier, the effective date of the new statute was October 1st, 2011, just a few weeks ago. Anything that was signed after 96, but before 2011, before October 1, 2011, it's called a legacy power of attorney. They're supposed to be still valid. Okay, legally, under the law, they're still valid. Practically is a very, very different situation. I can see one day, a year, 2 years, I don't know how long, a bank's going to say, okay, in their checklist of authorizing power of attorney transactions, is the power of attorney signed after October 1, 2011? And if it's not, we could argue, we could fight with the bank, we could jump through some hoops, but at the end of the day, there's really no teeth in the statute to sue the bank for failing to honor that legacy power of attorney. One of the other nice things about the statute is there's a specific procedure now that if they refuse to honor one of the new powers of attorney, the bank that is, you can sue them. You can hold them accountable for damages for failing to
If
fund.
I may, speaking to your question, when there's nothing much you can do, you just go forward.
Right.
And if the banks give you trouble, you just have your lawyer call the banks and work it out. Because there's really nothing you can do. Your mom can't sign a new power, presumably, because she's no longer competent. Would that be true? Yeah. So,
we're back to Tim's situation.
But you're really no worse off than you were before this new statute, because that's the teeth that you had for the old statute anyway.
Well, thank you, Craig. Thank you,
We'll stick
Mike.
around and take more
We'll
questions
stick around and take
afterwards.
more questions, but my commitment to you is to release you without embarrassment. We would appreciate response to today's seminar. We will see you next month. Have a great day. Hang around if you have more questions.
Thank you.